Good afternoon, Judge Goosen.
Good afternoon, Justice Brown.
How are you?
I'm fine, thank you.
Good. First, I must apologize that we kept you waiting for so long. Circumstances beyond our control, but do forgive us, please.
Fine, thank you.
Let's get right to it. You were you born in the Eastern Cape?
Yes, in
Born,
Kadaga.
bred, studied there, worked there, work there.
I studied at the University of Cape Town after school, but otherwise born and bred in Kadaga.
Yes. What did you study at the University of Cape Town?
I did a BA and then subsequently an LLB.
All right. I see that you started out as an article clerk, but then decided to join the bar.
Yes, I did. I didn't do a full period of clerkship. Started off beginning of '89, and then in May of 1990, I went to the bar to do pupillage.
Yeah. You were at the bar from 1990 until 2011.
Yes.
But then you interposed and worked with the Truth and Reconciliation Commission for, was it a year or 2 years?
It was just under 2 years, from April 1996 till the end of 97.
What exactly did you do with the TRC?
I beg your pardon?
What did you do with the TRC?
Oh, I'm sorry, Justice Meyer. I was the director of the investigation unit, the national director. I worked under the commissioner who was in charge.
You are appointed at the Eastern Cape Division. That's where you started out and that's where you still are, right?
Yes, that's correct.
Okay, since 2012.
Yes.
Okay. When did you start acting at the SCA? Just remind me.
I was appointed from the 1st of June 2020 until the end of May 2021. And then again from the 1st of June of this year, and my appointment is until the 30th of November of this year.
So you are there now?
Correct.
All right. How many terms is that?
I've now completed
In total?
five terms. The next one will be the 6th.
All right. How have you found the experience? Stimulating, I hope?
I have found it very stimulating. I've enjoyed it enormously. The first year was challenging, as you would know, because everything was done virtually. And so we weren't based at the court. Although in the May of 2021, I did go to the court and operated virtually there. But it was very stimulating and very enjoyable. Yeah.
Speaking about virtual hearings, I'm going to make a disclosure. You and Judge President Shenaz Mir at the LCC are the reason the SA was actually able to pull that off, be able to, you convinced me that it was possible to conduct hearings virtually because no one had done it. And then suddenly we heard that there was a judge who had just done motion court of all proceedings on the virtual platform. And then I called you and I did not know you from a bar of soap and you were brimming with all these ideas. And through your help, our court was able to carry on uninterrupted. Thank you for that. I don't think I've ever thanked you.
So it was a pleasure. I'm glad I could be of help.
Right. How many judgments have you written at the SCA?
I think it's 11, I think, from the previous acting stint. And from this term, there are a few that are at conference stage.
I see that you have a few articles, published articles under your belt.
Yes, I have.
All right. All right. I think that's it from me. I'll let my colleagues loose upon you.
Thank you. Thank you, Justice Mahar.
Colleagues, do you have questions for this candidate? I've only seen up to Commissioner Nyambi. Let's see. Delay. Any other hands? Okay. Commissioner Moiman?
Thank you, Deputy Chief Justice. Good afternoon,
Good
Justice
afternoon.
Goosen. Just one question from my side. How do you balance transformative justice and good governance displayed through one of your judgment that you refer to as part of your contribution to jurisprudence, Mazozo versus the Minister of Basic Education, against sometimes an outcry that there is judicial activism and judicial overreach. Premise on the assertion that when the judiciary set aside either executive decision or a legislative decision, it blurs the separation of powers. Thank you, Justice Goosen. Thank you, Deputy Chief Justice.
Yes, thank you, Commissioner. I think the Constitution requires transformative justice, and that means that the courts are required to act in accordance with the constitutional imperative. So when one's dealing, as in that instance, with the right to basic education, firstly, the interpretation of that right is to be informed by the concepts broadly of transformative justice. But one's ever mindful of the fact that the courts are not there to either legislate or to determine broad policy questions that fall within the prerogative of the executive. In that particular instance, it involved the assertion of the right to basic education, the provision of school furniture, and so what one was concerned with was how the executive government departments responsible for ensuring that those rights are met could do so. There certainly is scope always to place, in this case, the executive on terms, and I think that was the end result of that case. But it's a constant juggling act, and there are no easy or definitive answers one way or the other. They're usually driven by the facts of the case and the particular circumstances that one's dealing with.
Thank you, Justice Goosen. Thank you, Deputy Chief Justice.
Mic is off. Commissioner Nyambi, it's your turn.
Thanks, DCJ. Afternoon,
Good
Judge Goosen. One question from my side. What are the three attributes of a good judge, especially SCA? Probably if you can share with us those that you think you have.
Thank you. Thank you, Commissioner. I would think one of the first for me would be a commitment to to hard work, to engaging with the material that's presented. And I don't mean that flippantly. That hard work requires a level of engagement with the case at a particular depth. So that's one of the first things, that one's got to be prepared to really get to grips with the issues and the material that comes before you. I think one of the second attributes is being in a position where you respect your colleagues who are on the panel with you, that you're open to the thinking that emerges in the debate with counsel and with your colleagues, and that you maintain a sense of open and fair engagement with your colleagues. The third is that you are, even if you are not engaged or haven't given the task of writing the judgment, that you are, once the conference has been determined and more or less the outcome is decided and the scribe is busy working on it, that you prepare to offer whatever assistance through the research that you have done in preparation for that. I think those are three things that make it, that make the task of sitting on a panel at the level of the ACA that much easier. Of course, there are other attributes that one should have, but I think from a working point of view, those are the sorts of things that you need to bring to bear.
Thank you, Judge Wilson. Thank you, DCJ.
Thank you, Commissioner Nyambi. Commissioner Jess?
Justice Goosen, notwithstanding the fact that the jurisdiction of the Constitutional Court was extended, yes, but the SCA remains the apex court. It must develop common law. It must settle precedent. My question is, in terms of your own experience, are you a judge that is ready for the SCA?
Yes. Thank you, Commissioner Nochezi. I believe that I am ready, both in practice and in the time that I've spent on the bench. I've had the benefit of exposure to quite a broad range of work in areas where one would expect that those types of questions come before the Supreme Court of Appeal. I've dealt, for example, with shipping law. I've dealt with environmental law, some intellectual property matters. I have had exposure to local government and to planning law. I've obviously, as a High Court judge, dealt with the areas that are more regulated by the common law, contract and delict and the like. Although I claim no particular expertise in any of those broad areas, I believe that the exposure means that I'm able to deal with those matters. I can come to grips with them. You're quite right that of course, the Constitutional Court is the apex court. But the Supreme Court of Appeal has a very particular responsibility in the work that it does, I believe, in ensuring that the broader questions of precedent setting in the wide sweep of the law occurs in a way that is consonant with the constitutional imperatives, and that it can supplement the work of the Constitutional Court. And I would think that from the experience that I've had and my background, that I am able to fulfill that task.
Lastly, I think this is my last question. I've counted not less than 13 judgments you have written in the SCA. I'm not too sure, and
Thank you.
I was unable to count further on your reported judgment as the judge of the High Court. There are many. You agree with me, or you don't, on this one? My take, or what I want to suggest to you, is that the test or the standard expected of a person who is a candidate for a high court, where you look onto the potential of the candidate, and a person who is expected or was applying for the SCA, the standard should be different. That person must be an all-rounded judge, must be complete, and that can only be assessed through the judgments that have, that he or she has penned down. Would you agree with me? That's my last question.
Yes. No, I think that's a fair comment. The criteria for initial judicial appointment is, I would imagine, different to that which would apply when one is appointing to a higher court. And at the end of the day, the best indicator of the capacity of a candidate is from the judgments that have been written. That's one of the most obvious, because that's where judges are ultimately accountable. So I would agree with that assessment.
Thank you, Commissioner Matthews. Commissioner Pillay?
Thank you, DCJ. Good afternoon, Judge Goosen.
Good afternoon.
Judge Goosen, I really just have one question, and it's in relation to your judgment in the Serowitz matter.
Yes.
Now, that's a matter where Ms. Serowitz was poor and unemployed. She was the head of a household. She had in her household her daughter and granddaughter. She entered into a deed of sale for 40,000 Rand with Mr. Posthumous. And she borrowed the money and paid the 40,000 Rand over. And 4 years after he received the money, Mr. Posthumous was sequestrated.
Yes.
And she never got the property transferred into her name. I think she approached the High Court for assistance, and her real issue was how to get the trustees of the insolvent estate to transfer the property into her name. And what she really wanted to do was to compel the transfer of the property into her name. And I think it came before you and you dismissed the application. And subsequently, and I accept that at this stage, her case was amended slightly in the sense that she relied on some constitutional rights and applied to the Constitutional Court. She appealed against your judgment to the Constitutional Court.
Correct.
What struck me, Judge Goosen, was some of the sentiments that came out of the Constitutional Court judgment. And I just want to read just 2 lines of the judgment to you. The first is in the majority decision of the then Chief Justice. He says, this case is about homelessness and vulnerability. One of the many painful and demeaning experiences that the overwhelming majority of our people had to contend with during the apartheid era was not having a place they could truly call a home, and their vulnerability to the system's over-abiding readiness to evict arbitrarily. And then if one goes to the minority judgment, it's a judgment of Judge Cameron, you see a similar refrain, and what Judge Cameron says is the following. He says, it would be a disgrace to the law if there was no answer to Ms. Sarowitz's plight. The main judgment explains that the essence of a claim, etc., and that a case like this demands a solution from the law. Now, I just wanted to get a sense whether the social justice element, was that plain to you when you heard the matter, and how it is that you responded to that?
Yes. Well, I think that the case when it was argued before me was was pursued on a fairly narrow basis. I think in retrospect, I think there's no doubt that it's a matter involving an instance of a vulnerable person facing the possibility of eviction in the way in which it played itself out. But questions around the constitutionality and a direct challenge to Section 21 of the Alienation of Land Act wasn't a matter that came before me. The case, when it came before the Constitutional Court, was in fact quite a different case. Not only was the evidence, there was evidence presented at an appeal level, and the matter was prosecuted on a different basis. I accept, obviously, the result. And I think what the minority judgment points out is that the solution was not necessarily as easy a one, although clearly the majority, the solution was to read into Section 21 certain phrases, to read into the legislation a definition of a vulnerable person and the like. And the majority would have come to a different conclusion. The minority would have come to a different conclusion. I think correctly, it ultimately was about the position of a vulnerable person. But if you take a decision, and ultimately the Constitutional Court points out that you are wrong in that decision, that's an opportunity to learn and appreciate the basis. I had just recently another instance where the Constitutional Court came to a different conclusion to one that I came to in the Supreme Court of Appeal in the matter of Grobler versus Phillips. Obviously the Constitutional Court is correct. That's the position one adopts. But yes, no, I appreciate that what the case was about ultimately was how the Constitutional Court conceived it.
Thank you, DCJ.
President Betze.
Thank you, Deputy Chief Justice. Good afternoon, Judge Goosen.
Good afternoon, Acting President.
Earlier, you did mention that in every case where you sit, even in instances where the judgment has not been allocated to you, you assist whenever you can, whoever is the scribe.
Yes.
And in your experience at the court, has that kindness when you are described been reciprocated by the other members of the bench?
My experience is yes. Generally, when the panel, has deliberated on the at conference, and you have now go off and start writing your judgment, if there is particular assistance that any one of the panel feels that they can offer, they would do so. That's certainly been my experience.
Yes. One of the comments from Nadel,
Yes.
where they say the SA currently has 4 white men, and we're not certain if his appointment, his being a reference to you, will not lead to over-representation on the SCA bench. How do you respond to that?
I think that the figure is incorrect. There are, in fact, only currently 3 white males serving as permanent judges on the bench of the SCA. And that position, of course, is one that is likely to shift and change over the course of the next short while. I don't believe that appointing me at this stage would result in an overrepresentation. If I were to be appointed, then there would be 4 white males on the bench presently.
You are, of course, aware that there are many factors that must be carefully considered by the Commission when it comes to the appointment of judges, especially to a national appellate court like the SCA. You know, apart from experience, industry, scholarship, there are also the constitutional requirements spelled out, I think it's section 174.
Yes.
About gender and race representativity.
Yes.
Considering that the 5 vacancies that we currently have came about because 3 black judges retired, 1 black judge was elevated, and of course 1 white judge who was discharged from active service.
Yes.
What factors do you think or would you like the Commission to take into account insofar as you are concerned that you think should tip the scales in your favor, considering that there are 2 other white candidates, male candidates,
Yes.
and 2 white female candidates?
Yes. Thank you, Justice Petse. I accept that there would be, because of the constitutional requirement for demographic representativity, if you like, and that imperative remains, that there would be limited space within the 5 vacancies that are available. I would suggest that my experience, the breadth of that experience, the extensive commitment to transformation processes, both at the in practice and on the bench, that those would tip the scale. And I say the latter because I think if you look carefully at my CV and the type of work that I've done, I have the institution is what needs to be strengthened, and I have endeavored to do so through a process of training, mentoring, and, if you like, creating opportunities for people to be of their best within the institution. The commitment to the institution has meant that I do like to think not just about the work that I do as a judge. I try to do that to the very best of my ability. But I do constantly think about what the judiciary requires. And that has been, oh dear.
I'm sorry, I forgot to warn you. We were told that there was going to be load shedding around this time, but apparently it takes just about 1 minute to kick in. So let's just hold tight. It will be back on now.
Sorry, yeah. Shall I hold on, I believe?
Yes, please. Oh, there you go.
Okay.
Carry on, please.
Yes, thank you. Thank you, Madam Chairperson. Yes, I was saying that that
Oh, I'm sorry, Justice Hussain. I think the online
okay.
colleagues are not connected. Can you just check that?
I can you. Okay.
If you're not connected,
Well, if they can hear us, let's carry on. They don't have to see us.
Okay, thank you. Yes, as I was saying in answer to the question, Justice Pett said that I think what you'll find from my engagement in the profession and my involvement in training and mentoring and activities of that, that I believe in the strengthening as far as one can as an individual, the institution, whether it's in the profession or in this case now, the judiciary. So I do think about the judiciary constantly, about it, rather than not just only the work that I have to do. It's that process that took me into working, for example, with the judge president of my division around case management, took me during the period in COVID that Justice Meyer referred to think about what it is that we needed to do and do quite urgently around facilitating the functioning of the courts. So it's that broader commitment to the institution, I think, which is an additional factor that one can take into account.
Thank you, Judge Goosen. Thank you, DCJ. This
Thank
is
you,
where I leave
President.
it.
Commissioner Morumachai?
Thank you very much, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon.
I do note the fact that you stated at the outset that you are not an expert of all these, but you had exposure to them.
Yes.
And when I went through your CV, I realized that one of the areas where you have produced a judgment is actually the interaction or the intersection between pension law and family law. The case of Fritz, I'm not sure if you still remember that case. Fritz versus Fund SA.
Yes, I
Work
think
umbrella
funds at
fund.
work, yes.
Yeah, you still remember that case.
I do, yes.
I just want us to deal with that case. At the time when this case is, at the time when you delivered this case, there was a Supreme Court of Appeal case that was penned by President Meyer at the time, Krugel versus Eskom. I'm not sure if you are aware of that. I'm just surprised that based on the facts of this case, that particular judgment was not, because I see that your judgment was delivered a year later, because that judgment came around about 2011.
I see.
And your judgment, if I can see here, it came around about 2012. And of course, you referred to some of the judgments that are important, Siphelele and Maharaj. And we know from Peter's acting president at the time in Daba that Siphelele was wrongly decided. I just want to understand, when you are following precedent, and the extent to which you do your research, I know that there might be perhaps maybe the counsel before you might not have argued or referred you to a particular judgment, because I think there's a particular paragraph in your judgment that really is answered by paragraph 11 of President Maya at the time's judgment. I just want to understand, when you go through judgment writing and the extent of your research, and how you deal with precedent.
All right. No, thank you. One is you never rely entirely on the work that is presented to you by counsel. You have to do your own work. There's no doubt. I don't recall precisely. Almost certainly, if it was not referred to me in argument, if it had been, then I would have dealt with it. No doubt. But there are circumstances, I think, particularly in the High Court, as a judge, when you're working under pressure, that you may well miss a more recent matter. I have had often matters argued before me where quite eminent counsel have argued a matter where they haven't referred to the most recent authority, but where I've been able to find it. If in this instance I missed it, then I must have missed it. I haven't looked again at the case nor considered the judgment, but I accept that must happen occasionally. Yes.
No. I think that is fair enough.
Thank
I just want to ask you then, in relation to the law that was dealt with in that particular case.
Yes.
Obviously, in that case, you had a woman who came and wanted to claim what she thought was a pension interest from the husband at the time. But at least from the facts, it appears as if at the time of the divorce, the husband was not a member of a pension fund. And you proceeded, of course, to correctly dismiss the application. But my point is not there. I just want to understand, in relation to the way in which the pension interest is dealt with in this country and the law relating to it, Section 7, Subsection 7 of the Divorce Act, Section 7, Subsection 8 of the Divorce Act, and how it intersect with the Pension Funds Act. Do you, in your view, think that perhaps women, in particular, in most instances during divorces, are actually being prejudiced when these matters are dealt with? Do you think that the courts are dealing with these cases in the manner in which they should be dealing with them? Thank you.
Thank you. I would say that the scope for prejudice faced by women is significant. I'm not sure that I have, if you like, available to me the means to answer the question as to whether the courts are or are not applying this correctly. That would require a careful look at a whole range of judgments on the issue and an assessment of that. I've not undertaken that exercise. But I would certainly be, I think, conscious of the fact that when it comes to pension interests and intersecting with the position that women find themselves in upon divorce, that there is a great deal of scope for prejudice. Partly that's the reason why the legislature has sought to deal with it in the manner in which it has.
Thank you. My last question, Deputy Chief Justice. Have you ever written a judgment in the Supreme Court of Appeal, and that judgment you receive comments from your colleagues to the extent that it changes the entire judgment, and then the final product, it becomes different from the initial product, and then all the colleagues who are part of the panel agree with you and you release a unanimous judgment? Is that the practice general, where in that court people will be making comments to influence the judgment and ultimately it will be a different judgment?
Yes. Thank you. Well, it's not so much about comments to influence the judgment. The process would be that after the hearing, there would be a conference of the judges, and each of the judges would present how they would see and understand the case and what result they would envisage for the case. So at that, if you like, early conference stage, there would already be an exchange of views that would give the scribe, the person who's to write, an idea of whether the judgment that she or he is going to write is one that will be either a minority or a majority view. It certainly happens that in the process following a conference, further reflection and research and consideration may result in either the scribe or, for that matter, any one of the other judges changing a view that they might have had at the initial conference.
Thank you very much.
Yeah.
Thank you.
The alarm you just had go off, colleagues, was the 40 minutes he was allocated running out. So let's please keep that in mind going forward. Commissioner Matolo Lebu.
Thank you, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon.
No, mine is just a simple one. I see you have written a lot of articles about transformation. The one that interested me is the ethics as a driver of transformation in the legal profession. And I just want to hear your view, because for me, we are still talking about transformation.
Yeah.
And every day, and we are stagnating, actually, as far as I'm concerned, especially in the bar councils. What do you think should be done, actually, to transform the bar council?
Thank you, Commissioner. I'm not sure that I can comment directly on what should be done in the Bar Council. I'm quite removed from that. I'm certainly conscious of the fact that a lot more needs to be done within the profession, at the bar, or for that matter, amongst attorneys' practices to foster transformation, and that we're nowhere near where, if you like, we need to be. So I accept that entirely. The article, the focus was really on how we could marshal a deeper understanding of the ethical obligations of practitioners, and use that, if you like, as a driver for fostering transformation, broad transformation within the profession. As to what needs to be done broadly at the level of the bar, given that that was my professional background, I think high levels of support for new entrants coming in, intensified mentoring and training programs to ensure that new entrants, particularly black and women entrants, get the opportunities to build practices to allow them to sustain themselves at the bar. I think that's a critical element.
Okay, thank you, Deputy Chief Justice.
Thank you, Commissioner. JP Mlambo.
Thank you very much, DCJ. Good afternoon, Judge Goosen.
Good afternoon, JP Mlambo.
I just need to make one comment first before I ask a clarification question. I want to thank you. I mean, I'm here, I represent other heads of courts. I want to thank you for the instrumentality you introduce in assisting your head of court in the Eastern Cape, especially on the judicial case management front, and the assistance you gave to the DCJ when she was heading the SCA in them moving over virtually. As heads of courts, we welcome assistance like that from judges. So I want to thank you for that.
Thank you.
My question relates to what Commissioner Nojesi asked you. So I'm not sure if I heard what your response was. He posed a question to you that the SCA is an apex court when it comes to the common law. What was your response to that statement?
Thank you, JPM Lumber. I think that what I did indicate is that the Constitutional Court is the apex court, and it is the apex court in relation to all of those matters, including the development of the common law, because that development occurs obviously in the context of what the Constitution requires.
Okay, thank you.
But what I suggested was that the SCA needs to and must play an important role in providing support for the process at the Constitutional Court level.
No, thank you very much.
Thank you.
Thank you, DCJ.
Do we have, Commissioner Rukis? You want a second bite?
Just on this, I actually, I'm not sure whether I did, I qualified that.
Yes.
Every matter now, the SCA, because it has extended, I mean, the SCC, it has extended jurisdiction, where, you know, I raised the constitutional issue, public interest, and all those things.
Yes.
But I explained the role of the constitutional, of the SCA, not necessarily saying that it is the final court. I just want to correct if I'm understood wrong in that regard.
Yes. Yes, thank you.
Okay. Thank you, Commissioner. Are there any questions from the virtual platform? Commissioner Bernard?
Thank you, DCJ. Judge Goosen, just one, and it's on the matter you referred to, the Grobler versus Phillips.
Yes.
You sort of alluded to the fact that you accept the Constitutional Court position is correct. My question to you is, what was the difference in approach? You remember that the magistrate had ordered eviction, and then it went through the High Court and the SCA, and eventually in the Constitutional Court again ordered the eviction. What was the difference in the approach, and where did the SCA and the Cape High Court go wrong?
Well, I think that the difference between the two judgments is quite a narrow difference. The Constitutional Court, as I understand its judgment, suggested that I had, for the SCA, perhaps paid undue weight or given undue weight to the expressed wishes of Mrs. Phillips, and that was wished to remain. That was a factor that we took into account at the SCA, and the Constitutional Court placed that in perspective and came to a different result. So there's not a widely divergent difference in approach, as I understand it.
Thank you very much.
Thank you.
Commissioner Bredenbach, you appeared on screen for the first time today. Do you have a question?
It's the second time today. Thank you. My question has been asked already, so I'm covered. Thank you.
Thank you. Justice Goosen, it does appear that we have run out of questions for you. We've reached the end of your interview. Thank you so much for making the time to join us this afternoon. You're excused. Go well.
Thank you very much for having me.